Welcome to everyone who is joining us from across the country. I'm going to wait just a minute as I watch participants trickle in, and then we will go ahead and get started. Thank you for being here today. We're very happy to present on this topic. So again, welcome and thank you for tuning in this afternoon. We appreciate you taking the time to learn more about what's going on in higher education, and we hope making changes for the better. I'm Jenna Robinson, the president of the James G. Martin Center for Academic Renewal. Before we get started, I want to share a little bit more about our mission here at the Martin Center. As a private educational nonprofit focused on public policy, the purpose of the Martin Center is to renew and fulfill the promise of higher education in North Carolina and across the country. Since 2003, the Martin Center has been a voice for excellence in higher education. We are dedicated to promoting knowledge over credentials, restoring genuine liberal learning, and ensuring that public investment in higher education provides value to students, taxpayers, and society. We advocate responsible governance, viewpoint diversity, academic quality, cost-effective education solutions, and innovative market-based reform. We do that by studying and reporting on critical issues in higher education and recommending policies that can create change, especially at the state and local level. Today, we'll be discussing campuses' work on diversity, equity, and inclusion, and how those efforts have tended to intrude on individual rights on campus, specifically students' rights to free speech. Before we get started, I want to let all of you know that this event is being recorded, and we'll be sure to send a link to all attendees sometime after the event concludes. We'll also be posting the video on our website and on YouTube. I also want to mention that we'll be using the Q&A function for questions. You can add your question to the question box at any time. And at the end of the event, I'll moderate the Q&A and we'll try to make sure we get to all of the questions. If you're watching on Facebook, you can put your questions in the comment box and we'll be sure to get those as well. But first, we'll hear from our three panelists and I'll moderate a short discussion. I'm going to go ahead and introduce all three of our panelists right now, and then we will get started with Terry Pell. So Terry Pell is the president of the Center for Individual Rights in Education. Mr. Pell received his PhD from Notre Dame in 1996, his JD from Cornell Law School in 1981, and his BA from Haverford College in 1976. Prior to working for CIR, Mr. Pell worked as an attorney with the firm of Arendt, Fox, Kinter, Plotkin, and Kahn. And from 1985 to 1988, Mr. Pell was a Deputy Assistant Secretary for Civil Rights in the U.S. Department of Education. He later served as a General Counsel and Chief of Staff at the Office of National Drug Control Policy. Sorry about that. He joined CIR in 1997. Stanley Kurtz is a Senior Fellow at the Ethics and Public Policy Center. He has led the campaign to reform federal subsidies to academic programs of area studies under Title VI of the Higher Education Act and has co-authored model campus free speech legislation adopted by several states, including here in North Carolina. Mr. Kurtz's latest book, The Lost History of Western Civilization, which was published by the National Association of Scholars, offers both a critique of deconstructionist history and a new way of looking at America's cultural conflicts. Jeanette Doran is the president of the North Carolina Institute for Constitutional Law. Ms. Doran has served as president and general counsel of the North Carolina Institute for Constitutional Law, NCICL, since returning to the Institute to reorganize and restart the organization in July 2019. She is admitted to practice before the United States Supreme Court and United States Court of Appeals for the Fourth Circuit, various federal district courts, and all North Carolina courts. She is a frequent speaker at continuing legal education programs and has published scholarly articles in law reviews, white papers, and op-ed commentary. And without further ado, I will turn to Terry to kick us off.
Well, thank you, Jenna. I'm going to talk about a specific form of DEI education that's been somewhat controversial and has concerned a number of students who have contacted us. Namely the use of an online course or learning module that's designed to teach concepts of diversity, equity, and inclusion. One such course, the one that I'm going to focus on, is designed by a company called Ever5, and it's used by many schools. I mean, I was looking on the internet and I could right away find 25 schools that all subscribe to the Ever5 course. And what this course does is it uses short videos that depict everyday disagreements about diversity, equity, and inclusion as they might arise in student life, just student conversations. And the students who take this course are expected to view these videos and then answer some questions about them. And the thing that concerns a number of students who've taken the course is that through a process of elimination, they have to arrive at a single preferred answer before they're allowed to move to the next section. Another aspect that has concerned students is that along the way of viewing these videos and answering the questions are little pop-up windows that contain short definitions of terms like privilege, equity, tone policing, toxic masculinity, and so forth. What's particularly problematic, I guess, to the students who've contacted us is that the schools that use this course intend that it's going to become a basis for conversations that students are expected to have in everyday, campus life. So one school says that this course will ensure that all students have a common set of definitions for structuring daily conversations about equity and inclusion. So the course is designed to lead students to adopt a preferred conversational strategy for talking to each other about equity and inclusion when those issues arise in daily college life. And some schools go as far as saying that students are expected to learn and practice these recommended strategies. Well, the students that have contacted us are offended by the course. They view it as a form of indoctrination. They're forced to learn a highly ideological way of thinking and talking with fellow students. Moreover, the course seems to favor the perspective of certain groups, particularly groups that the course designates as oppressed groups, and denigrate the experience of other groups, namely privileged groups. So as a result of these individuals who have contacted us, we've considered how one might mount a legal challenge to this course on the grounds that it coerces agreement with controversial views about social and cultural differences. To put this in legal terms, the question is whether requiring students to agree to certain answers or preferred answers as they go through the course might be a form of compelled speech that violates the First Amendment. And just by way of explanation, just as it is well settled that the government cannot prohibit individuals from expressing an unpopular view, it's also well accepted that the state may not compel individuals to speak or adopt the government's favored point of view. And so because this course seems to force students to assent to a point of view with which a number of them deeply disagree, it's at least worth considering whether the course could be challenged as compelled speech. I should mention that it's a little bit difficult to evaluate a legal challenge here because the course is copyrighted and licensed and really only available for viewing by the undergraduate students at the colleges that have subscribed to it. We have not been able to view an entire version of the course, and it's quite long. It takes about an hour for most students to go through it. However, we were able to view one part of the course, and we have talked with students about other parts of the course. And based on this very selective example, I think it's going to be difficult to challenge this course as a form of compelled speech. And the reason is that the course is is designed in such a way that although it presents a lot of controversial material, it never really requires students to agree to much of anything that's controversial. So let me just go through one example here to give people a flavor of how this course works. The part of the course we were able to view asked the students to look at a video of a short exchange between a white student named Jeff and an Afro-Hispanic student named Jose. Jeff starts off the video by asking several clearly obnoxious questions to Jose. For example, he asks right up front why a person named Jose has such dark skin color, and goes so far to say that he was expecting something, quote unquote, a little more south of the border. Then Jeff goes on to challenge Jose about Black Lives Matter by suggesting that Black Lives Matter isn't quite right that in his view, all lives should matter. Well, the question posed by the course isn't whether Jeff is right or Jose is right, or doesn't require the students to take any position about Black Lives Matter one way or the other. The question is how two bystanders who observe this exchange should respond to it. And the course gives students three options, three possible responses. First, the first one is the bystanders can tell Jose or ask Jose to share his perspective with Jeff about why Black Lives Matter is important to him. The second one is that the bystanders can tell Jeff that he's naive, his comments are racist, and he has to leave. The third option is that the bystanders themselves can engage in discussion with Jeff about his comments and assumptions, which a little pop-up explains demonstrate white privilege on the part of Jeff. Well, clicking on each of these options calls up another short video that dramatizes that particular scenario, followed by a discussion among the actors about what went right and what went wrong, what's good and what's bad about each of these conversational approaches. And again, little pop-ups come up with explaining such concepts as stereotyping and privilege. Well, as you can imagine from the way I laid out the three possible responses, the correct answer is the third option, namely that the bystanders should engage in their own conversation with Jeff about some of his assumptions. This option is promoted on the grounds that it gives Jeff a chance to change his views. At the same time, the third approach suggests that the two bystanders ought to engage with Jeff themselves instead of passively relying on Jose to educate Jeff about what Black Lives Matter means to him. So the question, the compelled speech here, the question that everybody's directed to answer with a yes, is that the students must eventually assent to the importance of dialogue and discussion between students, some of whom view society as governed by stark differences in race and class, and others of whom clearly do not. A student doesn't have to dissent to either of these views, just to the idea that one has to be open and willing to talk about them. Most of the ideological content in the course takes the form of these little pop-ups about privilege and equity and so forth. But a student taking the course, a student answering the question, does not really have to agree with anything that's in these pop-ups or even read them very closely. And in any event, the pop-ups are presented in the voice of the course itself as a teacher. And the First Amendment doesn't really protect or grant a right to individuals to not have to hear the speech of others. So the objectionable material in this course is really in the voice of the course itself, in the voice of a teacher or the voice of the school. And there just is no First Amendment right to refuse or to not have to listen to material that one finds objectionable. So in our view, although there are problems with this course, a court considering a legal challenge on these facts is going to tend to favor the school. And it's going to be an uphill struggle, I think, to get a judge to strike down this course or find a First Amendment violation here. And it's because the schools do have First Amendment rights to present controversial material. Students do not have First Amendment rights to prohibit the school or go into court and prevent the school from speaking in its own voice about things that are controversial. So absent some clear case of compelled speech here, I don't think courts are going to be inclined to strike down this course. And so I think that we should probably not count on a legal challenge being a very effective way of raising the issues with the course. All that being said, I think we should be very clear about the nature of the indoctrination taking place here. And let me just mention three ways in which this course is clearly one-sided and is subtly presenting a view that students are going to disagree with. First, the course goes to great length to attack the view or to attack the idea of privilege, but the course itself subtly creates a privileged status for certain favored views that it says should be protected from challenge by others. So for example, the course repeatedly urges the view that members of oppressed groups should not be expected to educate others about the oppression that they claim is built into every aspect of society. On the other hand, individuals deemed to be privileged, like Jeff, are urged to engage in perpetual re-education designed to help them unlearn views that are deemed to be a product of their white privilege. So there's a very, the course treats different points of view very differently. Some of them are privileged, or some of them are protected, from criticism, and others of them are supposed to be open to criticism from everybody, essentially. Second, the course uses its own set of racial stereotypes, even as it cautions against racial stereotyping. For example, we've been told that apparently all of the racially insensitive privileged individuals in this course are white males. At no point does any video portray a minority race individual engaging in racial stereotyping. And then finally, and I think perhaps most troubling here, is that the definitions of terms like equity, privilege, stereotyping, and so forth are written in matter-of-fact objective language that suggests that these terms are well accepted, purely descriptive accounts of ambiguous everyday facts. Thus, in the section that I talked about, Jeff's insensitive questions to Jose are understood to be the result of Jeff's social class, which determines his response to obviously complex social situations and are subject only to ongoing re-education by helpful bystanders. In this case, the course presents it just as a matter of fact that Jeff is insensitive because of his race and because of his class, and that his somewhat determined responses should be open to criticism by all. So it's just a way in which the course itself designates certain ways of understanding complicated social situations through one particular lens, and it clearly favors that lens at the expense of all others. So there are very definite ways that the Ever5 course is one-sided and ideologically charged. However, I don't think a court would be very inclined to strike down the course on those grounds, because these types of manipulation could be easily characterized by the school and accepted by the court as essentially a pedagogical approach designed by the school to get kids to talk to each other. And presented that way and understood that way, I don't think a court is going to second guess the pedagogical judgments of a university effort to get students who disagree with each other to just start talking to each other. So while I agree that, I think we can all agree that there are problems with this course, that it's one-sided, that it's ideological, I don't think the best approach here is going to be to try to sue over this course. I don't think we are going to find a very receptive reaction from judges expected to hear this case.
Thank you, Terry. Next, we will move to Stanley Kurtz, and to those of you who have put questions in the questions box, we will be addressing questions at the end of the presentation. Thank you.
Thanks, Jenna. I'd like to talk about an issue that stands in background, I think, to some of the issues that Terry has just raised. This is the principle of institutional neutrality. The principle of institutional neutrality, which relates to the problem of compelled speech that Terry mentioned, but it's actually much broader than that. And it's part of the North Carolina campus free speech law. It's part of the underlying principles of campus free speech. And it may well be, in fact, I think it is the case that the course that Terry has described is a violation of institutional neutrality that may not be able to be adjudicated in court, but it is something that administrators and especially the Board of Governors of the University of North Carolina could act on, especially given the new law. So let me just talk for a moment about what institutional neutrality is. Institutional neutrality was given its classic expression by something called the Calvin Committee Report of the University of Chicago in 1967. That's K-A-L-V-E-N. And the basic idea is that institutions like higher education institutions, should seek to remain as neutral as they can on controversial public policy issues. Because if a university were to take an official stand as an institution, that would put a pressure on both faculty and students to hold that viewpoint. And so it would actually inhibit the free speech of faculty and students. So what are some examples? Well, if a college were to divest in fossil fuel companies, say, or divest in companies based in the state of Israel, that would immediately put a pressure on faculty and students to take one side of the public controversies over those issues. Let's say a school were to assign, as many schools do, summer reading for everyone admitted as a freshman, so that after you leave high school, you're supposed to read a book over the summer. And let's say the book that was assigned was, a laudatory biography of Bernie Sanders, maybe, or a book praising socialized medicine or some such thing. And by the way, these are only very slightly exaggerated examples, because when you look at the actual books that are assigned, in many cases, they are in fact very non-neutral with respect to public policy issues. So that all of those would arguably be violations of institutional neutrality. Similarly, if you are coming into freshman orientation and you're receiving this course, but the course is not from an individual professor, but the course is offered by the school itself as part of your orientation experience, then if the course takes a very particular ideological line on certain controversial matters, then very arguably the school is violating institutional neutrality. Now, it's important to keep in mind that there is no, and this was in the Calvin report as well, there is no perfect or clear demarcation, no line that is easily drawn as to where institutional neutrality begins and ends. Everyone acknowledges that colleges have to take positions on certain matters narrowly pertaining to their ability to function. So, for example, a university system needs to be able to appear before a state legislature and argue that it needs a tuition increase. And in doing so, it's taking a stand on a public policy issue. So the question is, what really pertains to the ability of the college to properly function, and what goes beyond that? And that is a judgment call first for the administrators to make, but ultimately for the Board of Governors in North Carolina, often called regents or trustees, various names in different states. Now, the North Carolina Campus Free Speech Law, as Jenna mentioned, was inspired by the Goldwater Institute's Model Campus Free Speech Bill, of which I was a co-author. And that bill both affirms the principle of institutional neutrality and creates mechanisms that encourage, in North Carolina's case, the Board of Governors to carefully look at what the administration does to see whether they cross that line of institutional neutrality. But there's something else that the law does as well, and that is it has a provision on this issue of compelled speech. I'll read it actually. The constituent institution may not take action as an institution on the public policy controversies of the day in such a way as to require students, faculty, or administrators to publicly express a given view of social policy. So when we were drawing up the Goldwater model, this is something we put in thinking that it would not become too much of an issue, that the main issue would be institutional neutrality in the broader sense and those judgment calls. But now that we have these diversity, equity, and inclusion courses and various forms of critical race theory informed training, this is increasingly an issue, even if in the case of this particular course, Terry is right that it may not be brought before a court in a successful way. clearly universities are flirting with this line. And there was a case that occurred before we drew up our model that we had in mind, where a social work school required certain kinds of political activities from graduate students in order to graduate from that social work school. So I would suggest, and having looked at, I believe, part of the very same course that Terry was speaking about, I very much agree with Terry that the course as a whole is ideologically tainted in ways that, in my view, are not necessary for the day-to-day functioning of the college. You can reasonably say that if a student or a professor are not prepared to treat equally, without respect to race or ethnicity or gender, their fellow students or faculty members, then you would have a real barrier to the functioning of the university. But these other issues about whether privilege exists and what should be done about it, and allyship, and all sorts of complex concepts that are part of this new ideological position that's become so prominent on campus, those, I believe, are issues that ought to be left up to debate for people within the university. And my last comments would be on the importance of the precedent of this provision I read in North Carolina. Now, it may be, as Terry said, that this particular course, it does not lend itself to a challenge in court, but they're flirting with going over the line, and they may well go over the line. You have legislation now offered in various states that would bar training that is based on certain particular concepts inspired by critical race theory. Some states may pass laws like that, some states won't. But there is this other approach of barring compelled speech, which fronts on some of these training situations. North Carolina is one of the just a handful of states that has this kind of provision. So if it were to become useful in this context, that could set a precedent, and other states may want to adopt that. Okay.
Okay. Thank you, Stanley. And now we will move on to Jeanette. Go ahead.
Thank you, Jenna. And thank you for all of our viewers today. I don't want to duplicate anything that Terry and Stanley have said. They've covered just about everything. But I think it's important for us as we have this conversation, and really for anyone who is engaging in this sort of dialogue about DEI training, to note from the beginning that this is not about endorsing discrimination or promoting bigotry. Sometimes I think there's this misapprehension that those of us who are concerned with the structure and format and content of these DEI training, that critics of the DEI training as we're seeing it develop are all a bunch of bigots out there promoting various forms of discrimination and bias. And that's not at all the case. It isn't for me. I don't know of anyone of the critics that I've spoken with at the DEI programs who have that motivation. This is really, it comes down to liberty. And I think it's important to remember that going back, Justice Jackson famously wrote back in the 1940s, he was a US Supreme Court justice. One of the things that he wrote was that one of the fixed stars in our constitutional constellation is that government doesn't get to decide what's orthodox in politics or other matters of public opinion. If we forget that, we're never really going to be able to maintain liberty as we know it. I also, now that I've sort of got that out of the way, but I think that's really important for people to remember. Just because someone's critical of DEI training as it's going forward doesn't mean that they're opposed to the idea of diversity in a general sense. They might be, they might not be. I also want to follow up on what Stanley and Terry have said about the North Carolina statute. I tend to agree with Terry that upon viewing some of these training modules, especially the one from NC State for its students, I don't think it's really likely that there'd be a successful legal challenge if we went to court. But I think looking at those videos, what we can do is compare that to the Campus Free Speech Act, and that passed in North Carolina in 2017. That's the institutional neutrality statute provisions that Stanley was talking about a few minutes ago. Just walking through that, there are several pieces to that piece of legislation, but one of them, perhaps the most important, is that the Board of Governors, which here in North Carolina oversees all of the UNC system, they were required to come up with a policy to protect free speech at all of the constituent institutions. And the constituent institutions are the individual colleges and universities within the broader UNC system. And that policy was supposed to have really 8 main points. Stanley explained the one on compelled speech, which is really what's been so much at issue in the DEI training module. There were several other provisions. And I think that's because back in 2017, the concern was principally on free speech, what people are allowed to say. There wasn't so much concern about compelled speech, which is why I think only one of those 8 real sections to the Campus Free Speech Act covered or related specifically to compelled speech. I think now's a good time for the Board of Governors to look at their policies, look at what's been going on at the constituent institutions, look at these training modules, look at the diversity statements that are being required of applicants for faculty positions that are being used in the promotion, retention of faculty and staff. Let's take a look at the facts as they've been developing since 2017 and even before. Compare that to the legislation that we have and find out, does the Board of Governors need to do something at their level, modifying their policies? Do we need to look for additional new legislation from state legislatures here in North Carolina, the General Assembly? Should we just tweak what we have? Where do we want to go with that? And I think that is a discussion that requires a lot of thought and consideration and debate from everyone, from students, from faculty, from members of the broader community, from legislators, from the Board of Governors, all of those groups. And for those of us who have been critical of what's been going on as it's been developing, as this DEI training program bandwagon has been developing, we need to provide support for students and faculty who have to live with this every day. We should provide support for the Board of Governors so that they know what's really happening in all of the many constituent institutions in the UNC system. And we need to provide assistance and resources for legislators as they consider revising statutes to enhance the statutory protections that students and faculty have. And this is going to be really important. As I'm closing out some of my remarks so that I know I leave you plenty of time to ask us questions, I think it's important also for people to keep in mind that a lot of what we've seen with the DEI training, as it's become sort of an area of focus and attention in the mainstream, so much of that started to pick up last summer and through to this spring, as we're getting more and more folks who are paying attention to it, and universities are increasingly requiring this DEI training of their students. So much of that has transpired during COVID, when students have not been on campus, when mass gatherings have been limited, when life has just not been normal. Okay? As students are going back onto campus, as campus life is returning to normal, probably this fall, I think there's a real risk that we're going to see students changing their behavior to stifle their opinions because they keep watching all these videos and their faculty keep providing all these diversity statements that tell them repeatedly what the right opinion is and what the wrong opinion is. And we're watching these training videos, just like the sketch that Terry was mentioning with the Jeff character and talking with the other student about the BLM protests. That assumed that Jeff's position was wrong. Every one of the acceptable answers assumed that this hypothetical white privileged student was wrong in his opinions. Well, that signals to everyone who has some concerns about their opinions that there is somehow a definitive wrong position on the matters of the day. My big concern is that this will know, before we know it, the effects of DEI training will simply be students refuse to engage in a robust discussion. And at the end of the day, don't we want that in an academic setting? We should have it everywhere, but most particularly in an academic setting. So I will leave it with that, turn it back to you, Jenna.
Sorry, y'all, I was muted. I always do that. Thank you all for your comments. I'm going to turn now to a few questions that I had to guide our discussion, and then we'll open it up to Q&A from our audience. So the first thing I want to talk about is that, we all want inclusion. We want equality of opportunity for all students. So why is this stuff controversial? And I will let, any of you take that question.
Well, I mean, I can speak to that. I touched on very briefly before, if by diversity we mean that a student or a professor is equally willing to engage or mentor someone regardless of their race, ethnicity, gender, etc., then I think everyone is pretty much in on diversity and inclusion. The problem is that those words in the context of DEI training mean something much more controversial. And let me just bring up one more of these incidents from this video that we've viewed. I don't know if this is the same Jeff, poor Jeff. I don't know what's going on with poor Jeff, but some fellow says to a Native American student that she really oughtn't to be purchasing jewelry and cloth from a local store that sells jewelry and cloth that look based on Native American designs, because it's just some kind of chain store and it's not really giving its proceeds to actual Native American artists. And the right answer here is that Jeff should not have said this because he's coming from a position of privilege. And so the real translation of this is that because of Jeff's race, he should not have expressed his opinion. So here we see not only is something being compelled, but the specific thing being compelled is an idea of privilege that displaces the equality of someone from a particular race. That's why this is controversial, because the concepts being purveyed by this training are actually in profound contradiction to the conceptions of individual rights and liberties at the base, not only of our constitutional democracy, but of liberal education itself.
Thank you, Stanley. Did anybody else want to comment on that question? All right, we'll move on.
Wait.
Oh, go ahead.
Yeah, I mean, I think people have mentioned this, but I just want to bring out one of the reasons this has become so controversial is that one side of this debate doesn't think it's debatable. And this is not just in the abstract. We're representing a client now who was an employee who asked some very reasonable questions about how the concept of equity might or might not apply to her institution. She did not express a point of view. She didn't even express doubt. She sort of expressed wonder, curiosity, and she was fired within 2 weeks. And her boss told her that to even ask that kind of a question betrayed lack of allyship for certain groups in the organization, and they did not see a way forward to keep her employed. So these concepts are being applied in very draconian, stringent ways that not only frustrate, robust conversation, but even bring fairly timid examples of it to a quick and certain conclusion. And I think the net effect of that is to make this perhaps much more controversial than it would have been otherwise, because there's no chance to debate any of the, reasonable questions that people have about this new approach.
Thank you. Let's see, the next question, I think we've kind of touched on it a little bit, but what exactly are diversity statements and why are they a concern? I think Stanley or maybe Jeanette, you brought it up a little bit, but they're being used more and more often. So tell us a little bit about what those are.
Well, it's interesting. I think it's one of those terms that doesn't have a singular definition, but essentially what they are is for folks who are applying for a position with a university, or they're looking for promotion, or they're seeking tenure track, they're asked to provide these statements about their commitment to diversity, equity, inclusion. They're very often encouraged to make them personal about their own experiences, and then set out sort of kind of a general path of what they'll do to promote diversity, equity, inclusion. The concern is how that's being used to screen faculty and administrators, not just for initial hiring, but for promotion. Are those faculty members who have a different view of what diversity means? Are they not going to make the cut? Are they not going to be hired in the first place? Are they not going to make tenure? And what will that do to shape the discourse on college campuses? What effect will that have on students' willingness to engage in a robust debate at school? Those are some of the problems, because it will end up with, we risk the possibility of a homogenized discussion based on just a specific accepted framework for what constitutes diversity, equity, inclusion. And that's part of the problem. But these are these statements, and it's interesting because you can go to various websites like the Writing Center. Carolina has one that's intended to help students and faculty members improve their writing. And they have a whole section on diversity statements. Most of the universities out there these days have some information on their diversity statements. And that's what they really are. It's just a statement of an applicant's personal experience. It sometimes, and I've read some examples online, they read a little like a kind of Oprah Winfrey interview, where someone just is pouring out all their own personal tragedy. Not all of them by any means, but then they also go through, what's your commitment to making sure that these specialized groups are particularly promoted and supported and enhanced, is typically how it's framed, but there is not a universal definition of it. I don't know if Terry and Stanley want to weigh in on that.
Well, I'd like to just note that the apt comparison has been made between diversity statements and loyalty oaths. Loyalty oaths were used during the McCarthy period of the 1950s And at the time, the University of California required teachers to swear that they were not members of the Communist Party or any party that would advocate the overthrow of the United States government. And maybe 30 or so teachers lost their jobs because of that. Now you have an only slightly more subtle version of that going on, where people are taken out of the first cut for job applications if their diversity statements don't meet the grade. And at one point, Berkeley actually made public its criteria for judging diversity statements. And if the diversity statement said, we have mentored people from many races, ethnicities, gender, that got you cut. You had to show that you accepted these ideas like privilege and allyship and all of these group concepts. And this butts up against legal issues like viewpoint discrimination. It affects academic research. A lot of professors have to talk about their research areas and the ways in which, say, they contribute to what is defined as social justice. So, for example, if you were going for a position for economists, it would push them to do research that was that focused on an enlarged state as opposed to a free market. So this actually not only affects who gets promoted, but it actually pushes research in a particular direction, which is the exact opposite of what the marketplace of ideas is supposed to be about. So I do think we're looking at an only slightly more gentle rerun of McCarthyism with these diversity statements.
Thank you, Stanley. I'm going to take a minute here to answer a question from Craig. He asked, what is the name and spelling of the course and the provider that we keep talking about? And the provider is Ever5, EVERFI. And the name of the course, I had it just a second ago, is Diversity, Equity, and Inclusion Training for Undergraduate Students. And I'm mentioning that now because I'm about to bring up another example from that course. So the DEI training course that NC State students and many others are taking, it's now been made optional instead of mandatory. But I'm going to read a snippet from that training and get your opinions about this particular snippet. So it starts out, Tanner, a white man, is planning what he thinks is a lighthearted salsa and sombreros theme for his birthday party. Oh gosh, I've lost my place. Okay, when Luca hears about it, they get angry because they recognize the event as cultural appropriation that makes fun of their Mexican heritage. They tell Tanner he should change the theme because it's offensive. Then the training asks, what should Tanner do? And you have three options. The first option is Tanner should respond, I'm open to hearing why you find it insensitive, but you need to use a less angry tone if we're going to talk about it. The second option is Tanner should respond, thank you for telling me. I wasn't even thinking about that. I'll make sure I spend more time learning about cultural appropriation to make sure I don't do this again. And the third option is cut off the friendship with Luca and spread the word that he is overly sensitive. In order to move forward in the training, you must answer with option number 2, as that Tanner should say, thank you for telling me. And if you choose the first answer, which I think probably a lot of students probably did choose, you will get this response from the training. Not quite. When Tanner demands that Luca change their tone and put aside their justified anger in order to have a conversation to educate Tanner on why his choice of party theme is cultural appropriation, he is behaving in a patronizing and disrespectful manner. Rather than policing Luca's tone, Tanner should take steps to educate himself further on the topic of cultural appropriation. To try again, select another answer choice. Is this not compelled speech, and why or why not?
I'll defer to Terry, but it sounds pretty compelled to me. And I would also note that this is remarkably similar to the famous or infamous incident at Yale that helped to kick off the wave of campus protests in 2015, where you may remember that the diversity office at Yale put out a memo telling people to be cautious about their Halloween costumes. And then a faculty member, and I can't remember whether his
It was
wife, Christakis,
Erica Christakis.
I don't know whether she was on faculty or not, but I think she was actually. She just wasn't the master of the house there, but she was on faculty. In any case, she put out an email saying, well, you're taking this all a little bit too seriously. I think people are mature enough to choose their own Halloween costumes, give it a rest. I'm obviously paraphrasing. And this started a massive national controversy that is still very far from resolved. So here's an issue where clearly the jury is out in terms of what the public in general thinks.
I mean, I think this example comes closer to the line than some of the other examples, because although the question or the answer that the student has to accept is really about what the video calls tone policing, on the way to getting there, the student has to read and probably accept a lot of other stuff that he may well disagree with, including privilege and other controversial concepts. So, I mean, I think this one is probably more loaded with ideological content than some of the other ones. And I think there's certainly grounds for objecting to this. I'm not sure that it would succeed in court, but I don't think that's really the point here. We do need to be aware of what this course is doing and how it's working. And this is an example where it's taking a common sense idea, like you should not argue with somebody or you should not immediately dismiss somebody who is disturbed about something you say, and cloaking it with and giving it all kinds of ideological freight that that is controversial, and that somebody might well be offended at having to answer this question, thinking that they're agreeing to all of the surrounding ideology that sort of pops up in these little windows as you get to the right answer. So I agree, this is worse than some of the other ones. And I'll just leave it at that.
Well, to follow up on Terry's remarks, I agree with both of my co-panelists that I agree with Terry that this is the closest or perhaps the most egregious. I also agree with Stanley that it sure sounds like compelled speech, but I think what's important to remember, and it's very, very difficult to have this presentation without being able to show these clips or show screenshots of this copyrighted program. You can't just look at this in a vacuum. The students are seeing an entire hour-long presentation, but for those of us who have experience litigating constitutional issues, you can tell, looking at the videos, that they were very carefully crafted to walk right up to the line. So they don't quite go over it. And if they do, it's just a little toe over the line, so that it is a lot harder to convince a judge to throw the whole thing out, just as a practical matter. Judges are human beings. They tend to have at least some common sense. But what happens is, if you're the 18, 19, 20-year-old student watching this, you're not watching an isolated segment of the video. You have not been to law school. You have not been practicing constitutional law for 20, 30, 40 years, like we all have. You're looking at it and it feels a lot like you're being forced into a political orthodoxy that's been established by government, in this case, the institutions. So I think that's an important part to remember, is that these videos, I think, come right up to the line and seldom, if ever, really cross it. But this is certainly one that, from a student's perspective, would feel like compelled speech. From a lawyer's perspective, might cross the line, might not. But we shouldn't have to get into that kind of hair-splitting discussion. Because again, imagine you're the college student and all of your universe, your dorm mates, your buddies from clubs, your fraternity and sorority sisters, your faculty members, your advisors, all of that, everywhere where you effectively live and work, is shoving this down your throat. That's how it should be viewed.
Well, sorry, go ahead, Stanley.
Well, I just think that's a hugely important point, and I wanted to fill it out just a little more, building on the example I gave before. You take that fellow who was told that he should not give his opinion about where you should buy Native American artifacts from because he was coming from a place of privilege. So the very next thing in the video says student viewpoints. Okay, so already in lawyers' terms, it's set off as just the viewpoint of some students. But it comes right after the thing that says the fellow shouldn't have spoken up because he's coming from a place of privilege. And the student viewpoints are, how should we deal with privilege? So then one of the students said, well, we should empower minorities and their movements. Okay, so now they're literally telling students to join a particular kind of movement. Now, technically, legally, that might mean the walkaway movement in which minorities are encouraged to vote for Donald Trump. But that's probably not what the student on the video has in mind. And they're talking about privilege. Now, again, it's that student's point of view. It says a student point of view, but it's a point of view of how to deal with privilege. And it follows right after the compelled speech thing where you can't advance unless you say the fellow who spoke about the Native American artwork was speaking out of turn because he had privilege. And so all of these things are designed to, just as Jeanette has said, to protect legally. But the overall effect for any ordinary person taking this is to be indoctrinated, just flat out indoctrinated. But they're coy about it and clever, but that is what's going on.
Yeah, I think this goes back to something Jeanette said earlier. These online courses are being given to students during a time when they're not on campus. So we don't really know what the effect of this type of indoctrination is going to be when students return to campus. If it turns out that there's a lot of policing of speech that takes place as a follow-on to this, online course, and uses the online course as part of the rationale for meting out punishment to people that don't, follow the directions that the course suggests, then I think we would have a very different case. And I think it is going to be interesting. I mean, more than interesting. I think it's important to know what types of speech get effectively silenced when the students come back to campus as a result, not just of this, but a lot of other things. And I think again, jumping back to putting my lawyer's hat on for a second, a much clearer case to litigate would be one involving a classroom where a teacher is presenting this material in a way that's designed to indoctrinate the students. And then instead of clicking little boxes in an anonymous online test, for example, white students would be forced to stand up and admit their privilege and admit things or confess things like the fact that they're, fundamentally racist as a consequence of their privilege, or inherently racist or something like that. I think once you move into a situation where somebody is forced to express views that are humiliating and that they don't agree with as a condition of successfully completing a course, that is a very different set of facts that I think would be very easy to litigate. Let's put it that way.
Well, for an example, another portion of, if I can just follow up real quickly on that, another portion of this same module is dedicated to spotting the privilege. So students are being asked to confess or admit to their privilege. It's just the privilege. But again, in the context of the broader video, I think the average student would understand that the privilege is their privilege if they happen to fall into one of these categories that the video has already made clear is the privileged group. That's yet another example of how I think the video, and not just this video, but similar videos, are carefully constructed with this. If you've got to really parse the words, and maybe it'll be different a year from now when we have specific facts of what the result has been, when we've got some examples with how this actually plays out when we've got students living in the closed universe that is on-campus college life.
Yeah, I'm going to ask you just one more question so that we can get to the questions from our attendees. And my question is, are there policies that states or boards can adopt to prevent DEI efforts from trampling student speech or policing student speech? And is legislation a good idea?
Well, I certainly, I guess I'm biased because I've sponsored various forms of model legislation, but I do think legislation would be a good idea. Now, people often say, and they said regarding campus free speech laws, well, the First Amendment is already in place on college campuses, so we don't need a campus free speech law. Well, yes, the First Amendment is in place, but the problem is the powers that be are not enforcing it. In fact, not only are they failing to enforce it, but they're directly violating it. And it turns out to be very helpful to pass a law that lays out clarity and enables people like boards of governors in North Carolina to put pressure on administrators to uphold their responsibilities under the First Amendment. So even if compelled speech is a problem, I think laws are necessary. And I want to make one other point in that regard. We have had litigation against things like campus so-called free speech zones, these little postage stamp size areas where they say you have to restrict your free speech, or restrictive campus speech codes. And this has been going on for maybe 3 decades. And 9 times out of 10, or maybe more, the free speech side wins those cases. We win. Victory. Well, it's been 3 decades, and maybe 25 or 30% of schools less than previously have those speech zones and speech codes, but they haven't been fully defeated. And that's why I think legislation becomes very useful, not in place of, I'm not negating the importance of litigation. And in fact, litigation becomes an important tool under the legislation if you create a cause of action. But I do think you need legislation in addition, because what we're looking at here is large-scale efforts to flaunt the Constitution and all of the principles and laws that flow from that. And we've got to answer that back.
Okay, thank you. I'm going to turn now to questions from our guests. And this first one comes from Jamel. He asks, do you find that higher education institutions have to choose between protecting free speech, or liberty as we know it, as Jeanette called it, and the protection of students from marginalized groups? If not, what would you suggest as an institution do to engage in both actions?
Personally, I think it's a false choice. I guess I'd have to hear in part what students from marginalized groups need to be protected against. The idea of a free speech, of a safe space, say, is the idea, it is justified by saying that a student in a marginalized group needs to be protected from certain kinds of speech. I find that problematic. Now, that is not to say that people should not, and that universities should not, advocate respect. They should. And going back to to the Yale report. I'm forgetting the name of the famous, what's the famous Yale report on campus free speech? Oh, well, in any case, going back to the earliest classic documents on campus free speech, it was always said that although freedom has to take priority, that does not and should not prevent a college from telling people that they should speak with respect. But protecting people against the free speech of others, when we've always learned that the best remedy to a false opinion or an opinion that someone thinks is false is more speech, speech to contradict that. That is the way to remedy, not to protect per se, although again, respect is crucial, but rather to answer, to reply, to investigate, to explore the issue, to debate the issue. I think if we had more debates on college campuses, people would actually feel more protected. We don't have many debates. I have model legislation on campus intellectual diversity that would help colleges to create debates and panel discussions. And yes, that would involve clashes. One side of those debates might say things that made people who oppose those views uncomfortable. But ultimately, if we had those debates, I think people on all sides would feel represented, and thus they wouldn't feel all of this need to self-censor. So I think to some degree, we have to thicken our skins and hear a clash, but ultimately the clash will help us all to feel protected, because we'll know that in the marketplace of ideas, there are people out there speaking for us.
Thank you. The next question comes in from Facebook. Hold on, I'm trying to get it. There we go. How much of the willingness to shut down debate stems from the inability to defend one's own position? It's so much easier to shout down your opponents than to develop a coherent argument in favor of your position. Anybody?
I think that's more of a cultural question or psychological question than it is a legal question. But it certainly feels that way just from a gut perspective.
I mean, I think that, one of the very frustrating things about the Ever5 course is that it is trying to break down barriers, trying to break down defensiveness, trying to promote honest conversations between students who probably deeply disagree about certain things. And they could have done it. They could have written a course that did not have all this ideological freight with it and did not require certain individuals to be put on defense the whole time they're taking the course. It could have been done in a way, based on just simple notions of respect rather than these complicated, freighted notions of privilege and allyship and all the rest of it. And I think in a real way, it's a missed opportunity. But that would not prevent other schools from developing other courses that do a much better job of this. I mean, it's just, this course is bad and it's one-sided, but it could be done in a much better way by other schools if they wanted to do it.
There's also there are at least two explanations of why so many students and faculty are so sensitive about dealing with contrary viewpoints. One is the sort of snowflake theory, the idea that children have been raised in the last generation or so with helicopter parents. They've been pampered and overprotected, and they're not used to anyone contradicting them. And people point to, I remember one set of shout-downs or interference with a talk by Ben Shapiro at Wisconsin, and the students in the audience kept shouting, "Safety, safety." So this is the idea of the snowflake argument, but I think personally, I think that has been a little bit overblown. And this really is more a question of ideological indoctrination, and people really don't want there to be another perspective, because that would leave the issue as a debate when really they're out to convert. And it is remarkable how much power even one or two voices of dissent on a campus can have. You look at Robbie George at Princeton or Hadley Arcus at Amherst. It's very powerful to have even one or two respected voices on a campus giving an alternative point of view. Because as I said before, with debates, it tends to validate the other side and to show that an issue hasn't been resolved. And I think this is why there's such a drive to silence people. It's true that they're not used, the people who do this are not used to defending their own position. But I think there's also an interest in literally wanting to almost forcibly convert everyone to their position in a quasi-religious manner. And the way to do this is to silence opposition, to convert debate to fealty to a particular quasi-religious point of view.
Jen, I know we're already, I think, a few minutes over, but I did want to follow up on what Stanley was saying about the power of one or two strong dissenting voices in the discourse. One of the previous questions you asked involves someone saying liberty as we know it, as Jeanette put it. Well, that's liberty as we know it. One or two strong voices speaking out against tragedy and injustice and convincing other people that certain things are so wrong that society will choose a particular path. We persuade our fellow man, a fellow woman to do or not do things. And that's liberty as we know it, is the power of persuasion in execution.
Excellent. I think I'm going to try to get just a couple more in and we'll get some quick answers from you all. This is a question from Frank. He wants to know, are you suggesting that companies and organizations are not entitled to hire people that fit the culture or organization?
Well, we really aren't speaking about companies here, private companies. That is an issue that needs to be discussed, and I do have opinions about that, but we're speaking here about public universities who are responsible to the people of a state and the full spectrum of political views represented in every state in this union. And I think public institutions in particular, note that the Calvin report from the University of Chicago, that was a private institution. And even at a private institution, and the University of Chicago is famous for its support of free speech, the idea was we should not have an institutional position that inhibits our faculty or students, because the true purpose of liberal education, even at a private institution, is pursuit of the truth. And that is best done through freedom, through liberty, through freedom of speech. But particularly at a public institution, which is funded by taxpayer money, taxpayers of all points of view, and which hosts the children of the citizens of that state, and then those children come to voting age and become adults at the university, particularly there should be a respect for institutional neutrality, because it is an institution of the state, which above all should not be pressing one ideological view onto the people that it is serving.
Excellent. I'm going to do one more question, and part of it is because I want to answer part of it myself. This is a question from Leslie. She wants to know, given the fact that tensions related to diversity and race have continued to escalate in our nation, is there an approach, a program, a course, etc., that you would recommend or have seen that would help students gain knowledge and skills to engage with these issues that would not violate free speech? I would hope we could help this generation be more effective engaging across difference and effectively discuss these difficult topics. And the first thing I want to say is that the Foundation Against Intolerance and Racism, a new organization called FAIR, you can find them at fairforall.org. They are going to be developing DEI trainings of their own, and they come at it from a very different angle. They are interested in, as you said, discussion, discourse, equality of opportunity, the fact that we are all human, looking at the things we have in common instead of the things that divide us. And so I'm very much looking forward to those trainings coming out. And I also want to give a shout out to the Program for Public Discourse at UNC Chapel Hill, which models how people can disagree respectfully and have conversations in which they discuss very fraught topics successfully and realize that you can disagree politely, you can disagree amicably. And I think, I'll also recommend what Robbie George and Cornell West have been doing, with their roadshow. I guess they're not doing a roadshow right now during COVID, but showing how they can disagree very vehemently and still be the best of friends. And I think that is the way forward if we do want to teach students to disagree and to confront controversial issues and to really embrace academic freedom and inquiry on campus. But I'll be quiet now because I'm just the moderator, and I will let my panelists take that question too.
Well, who could follow up on that, Jenna? I thought that was a fantastic response.
I'm good with all that, but I would add that the ultimate solution from my perspective is a return to the principles of classical liberalism, which doesn't contradict what you said, Jenna. But I think by returning to classical liberalism, which treats us as individuals, first and foremost, rather than members of a group, we have the real solution. In other words, this is a little bit like Dorothy clicking her heels 3 times. We had the right solution all along. We just lost it. And once we go back to individual liberty and people having rights as individuals and not telling people that they shouldn't give their opinions because they are either privileged or oppressed or whatever, we have the greatest solution in the world to overcome ethnic, religious, and racial hostility. And it has worked. Of course, it has been imperfect, but it has improved and gotten better because we have focused on individual liberty. And if we extend that further, we will continue to succeed. As soon as we think of ourselves from the first premise as primarily members of a group, we're already behind, we're already in trouble. So rediscovering classical liberalism is the solution, and we've had it all along.
Thank you. And, I think we're going to end right there. I want to thank everyone today for tuning in to the webinar. I apologize to those, the questioners to whom I could not get today. And I will try to forward questions to the panel. I see a question at the end. Can you forward my questions to the panel? And I will do that. And again, thank you to everyone who makes our events possible. Thank you to our donors, our viewers, our readers, those of you who click on our newsletters every day to find out what we're doing. And thanks again to our panelists for being with me here today. And everybody have a great afternoon.
Thank you so much.
Thank you.